Yesterday, the 1st of October 2025, there was an interim ruling on miscellaneous application number 824, which arose out of miscellaneous application number 823 of 2025. Both those applications as well arose out of the judicial review application before the High Court Civil Division, which was filed by the Honorable James Michael Akena, the party president of UPC, and the Uganda People's Congress, the party itself, against the Electoral Commission. In that prayers for judicial review, the Honorable Akena and UPC was seeking an order compelling the Electoral Commission to nominate him to contest in the 2026 general elections. Out of that, the High Court yesterday ruled on the interim application to the extent that, one, the letter or the decision by the Electoral Commission communicated on the 22nd of September 2025, pronouncing itself that the Uganda People's Congress executive or cabinet had ceased to exist on the 1st of August 2025. That decision, court has restrained the Electoral Commission from implementing it. What it means is that the party president of UPC and his entire cabinet, for now, are allowed to transact business for and on behalf of UPC until the determination of the judicial review application. Secondly, the judge was not in agreement with the prayers to order the Electoral Commission in the interim to nominate the Honorable James Michael Akena. The judge appears to suggest in that ruling that when he determines the main application, he will make the final pronouncement, because this interim application arises out of the main suit which is before that court. So what it means is that for now, the Honorable Jimmy Akena cannot be nominated until the suit is determined in its finality. It also means that he cannot campaign. He cannot go out to Ugandans to sell his ideas. It also means that the UPC has been denied in the interim this opportunity to do like the other political parties. But we hope that when the matter is finally determined, it will show that the applicants are right, and such an order, no matter how late it is, will go a long way in sanitizing the electoral process in this country.
So, for you, in your opinion, you think that the magistrate, he could not, you think that he had powers
to court with an interim application? It is similar as if you are asking for some form of first aid to be given to you, but still you need to be taken to the hospital. In the opinion of the judge, he thinks that going to the hospital is more important. So instead of wasting maybe time on the issue of the first aid, for him, the court prefers that the main matter be determined. And it is discretionary. When you go to court and ask for an interim remedy, the discretion is with the court deciding to either grant it to you or not to grant it to you. In the end, even when they have refused to grant it in the interim, sometimes in the final orders, they grant you that remedy that you require. The political implication is that it paints the NRM and the executive arm of government as that which is not pro-democracy. It paints the NRM as fearful of competition. It waters down all other narratives that have been made in the past. For example, in the 1980, you know that many candidates were allowed. Some of them were saying very bad things that I think if any other candidate said now, they would be arrested and thrown in like Dr. Kizza Besigye. But in 1980, despite having control of government or influence over government, all the candidates were allowed. So I think the people of the membership of Uganda People's Congress across the country, and especially in the stronghold that you know, Lango, Acholi, Teso, and even in the east, we shall not take it lightly. I think that someone is going to pay heavily for that mishap. As UPC, we are law-abiding. We took the decision to go to court. We had the numbers to do other things, but we also believe in the rule of law. We opted to go to court to demonstrate that this is actually not necessarily purely a legal matter. It is a political question. So whoever is afraid to face the UPC on the ballot at presidential level, whoever is afraid to face UPC at whatever level, should actually prepare a better message, and which may discredit UPC. But as you know, we have the track record. So we still insist and maintain that the decision to refuse to nominate the Honorable Jimmy Akena is not a legal matter. It's not on the basis of law. It is just an abuse of power. It is an abuse of authority. It is out of influence, because he had met all the requirements and the circumstances under which an aspirant may not be nominated was not. I can even tell you that even if he was to be refused nomination, there is a provision in the nomination papers where the returning officer receives you at the nomination ground, looks through, and then endorses you as nominated, or nomination refused and writes. That's the law Parliament made, that you cannot prevent somebody at the gate. You have to give your reasons when the person is properly before the Electoral Commission, and we agree that that has not happened. That is the gist of our submission in the application for judicial review, that the action of the EC was illegal. When a matter between parties are before court, and let's agree that several members of UPC are in court contesting on who should be leading them, that question has not been determined in finality before the courts of law. So we wondered how the EC, constituted for purpose of election, turned itself and started to give a ruling, to give a decision, as if they are adjudging between the parties. Is the EC clothed with powers over and above the courts of law, for example? I think my answer is no. So EC should have been patient, should have referred anyone who is aggrieved to go to court, and then wait for a final order which would come from court directing them to do otherwise. In this case, it did not happen. That's why we hold that that action is illegal and unlawful. People are very angry. People are feeling betrayed, because when you look at the geographical spread of the candidates, you see as if there was an agenda against the people from the north, the greater north. From West Nile, Lango, Acholi, Karamoja, we have not been able to find anyone offering themselves this time. So it was also our pride that our own has come up to market his ideas. We have seen the rest of the regions have been have candidates nominated. So that anger is there, but we have called upon our people to remain calm. Indeed, there were some voices which wanted to express their dissatisfaction in other ways, which ways are also constitutionally guaranteed that they can. If they want to express, they can within the ambits of the law. But because we had petition court and we were hopeful of finding a remedy, we decided to ask them to remain calm, and we will be guiding them, because there are so many tools we have at our disposal to respond to the chief technocrat, the chief architect, the chief sabotager of UPC participating in elections. We know, and we are going to respond, whether politically or legally, but we are going to respond.
Thank you so much.